I know we hate debates about definitions, and frankly, I hate to be that guy, but because the opposition did not challenge our definition in the first speech, due to just the simple laws and rules within this association, they cannot challenge our definition. But even if they did, since the resolution is extending the constitutional right of freedom of the exercise of religion to corporations, I don't know exactly what they want us to do. We're going to continue to affirm this resolution in the way that it has been defined and in the way that the scaffolding of the definitions have created this debate. So now with that, I'd like to go directly into their contentions, show why they clash, and if time permits, go back and further crystallize upon our own contentions. Now, in one of the speeches that previously happened, they mentioned their second contention, which is that the idea of extending the freedom of exercise of religion creates an incredible and unjust discrimination. Now, they mentioned the idea, we, in cross-examination, asked them about if a company could still be successful if they practice racist or unfair techniques when it comes to their business, such as not providing a service to a specific race. And up came the discussion of the Heart of Atlanta Motel. And our opposition said that yes, they were able to continue to be successful, as were countless other organizations during the civil rights period. However, what they did not get to mention was that in 1964, I believe, when this case actually made it to the Supreme Court, those two deadly words that they hate on the negative side, this was struck down. And the idea of having these racist techniques and practices by companies was struck down by the Supreme Court and thusly enforced from then on. On side affirmative, we're not trying to bring that back. If anything, what we're trying to do is simply protect the rights of businesses and business owners when they want to make business decisions, if they are religiously motivated and do not specifically discriminate against one group or another. Now, when we're talking about the issue of contraception, this has become an issue of hot debate between the two groups. And now I'd like to first begin by saying that although on side affirmative, we're not saying that women should not be given the right to have contraception. In fact, the opposite, they should have that right. We're saying that by trying to force business owners into something that would go against what they believe, and in the free exercise of religion, just so that a few other people could find a slightly easier way to find these methods of contraception, we're actually going against what they're even saying. And that, in and of itself, is unjust discrimination against business owners. Because, hey, it's only their conscience. It's only what they believe. And so, therefore, that's not nearly as important. Instead of looking for other viable alternatives, which have been mentioned by Supreme Court justices, which they hate to hear. They hate hearing about the highest court in the land, just disagreeing with everything they have to say, unless there's a case or two that actually goes their way, in which case that is the Supreme Court of the land, the supreme law of the land, and we should obey that. I know this debate is about what we should and shouldn't do, but when there is an overwhelming precedent set by the Supreme Court and the United States federal government, sometimes it's kind of hard to overlook. You can't nitpick the United States of America and their Constitution and what the Supreme Court justices rule. And through the ideas that are defended in our three contentions, such as the Citizens United versus FEC, which ruled that these corporations could be people rather, or the Hobby Lobby case, which ruled that they did have this idea of free exercise when it wasn't discriminatory. You can't ignore those kinds of facts. And for these reasons, I urge an affirmative ballot, and thank you for listening to my voice.